Welcome everyone to Reinhardt's webinar on Don't Miss the Omnibus, the HIPAA Omnibus, which is leaving soon. We'll be talking about strategies for complying with HIPAA-HITECH regulations, the new regulations that were published earlier this year. My name is Rob Heath, and I'm chair of the Long-Term Care, Assisted Living, and Senior Housing Group at Reinhardt. And we are delighted to be able to talk with you this afternoon about HIPAA-HITECH. And we'll be discussing key compliance to-dos on a going forward basis. And we'll also be talking about post-September 23rd issues and planning. Heather Field, who is a shareholder in Reinhardt's healthcare practice, and is certainly, in my opinion, one of the most knowledgeable HIPAA experts in the state, primarily doing the presentation today. HIPAA is a challenging area and one that requires thought, planning, and strategy. Heather will lead us through a discussion of the new regulations, the requirements, and will also help us to think through on a practical basis what needs to be done currently, and also the challenges for operationalizing HIPAA on a going forward basis. Heather?
Thanks, Rob. We're delighted to be here today, and thank you all for attending. I think that for many of you right now, you may be feeling like your head is spinning a little bit in terms of how do I get my arms around this. It really is going to happen. And you would not be alone. So I think the first thing I would say is that it is not time to hit the panic button. And we are helping a number of clients that are just starting to figure out what they need to do. I think that the key thing is that you focus on the highest risk areas, and we're going to talk about what those are and focus your attention on those first. And then you would not be alone if you're going to be spending the next few months figuring out all of the implementation issues that go into fully complying with the rule. So in terms of key dates, this regulation was published January 25th. That date is particularly relevant for business associate agreements, and I will go through in a moment why. The compliance date is September 23rd, so it is nearly upon us. And I think that what I've tried to do today is really focus on what you must do this week as soon as possible, and that is update your notice of privacy practices. I think that's the number one thing. Secondly, I think you need to get your arms around your business associates, understanding that the definition has changed and expanded a bit, and the stakes are a little higher than they were before. Third, not the last, is to update your breach notification policy and procedure. But I think more importantly, it's important that you realize how the breach standard has changed so that come next week, you are able to implement in practice, if not yet fully in policy and procedure, the intent of the law and make sure you're in compliance. There have been some other changes to the fundraising, marketing, and sale of PHI provisions as well as individual rights, and we will touch upon those. But first, the notice of privacy practices. And the interesting thing is this is one of the few aspects of my job that all of my friends and family actually understand what I do, because everyone has gotten a notice of privacy practices, I am certain, on this phone call and here in this room. And my family thinks it's actually quite humorous that I would participate in helping draft that document that everyone immediately throws away. It's not the kind of thing your mom is proud to tell people that her daughter helped write that. Having said that, let's talk about what needs to change in the document itself. OCR is particularly concerned that people understand how their information is being used and disclosed. So they have added a requirement that the notice explicitly identifies certain uses and disclosures that would require authorization. and that's really important to the government. So we've added language to the notice for our clients addressing that. You need to identify in the notice that folks have a right to opt out of receiving fundraising communications, that they have a right to be notified if there has been a breach of their PHI, and that they have a right to restrict redisclosure of their PHI to health plans with respect to treatment that they pay for out of pocket. For those of you on the phone with us today, I'm guessing that that is not a very common occurrence. This does happen more in areas of bariatric surgery, plastic surgery, things where people are concerned about creating, or that there might be some worry that there would be a pre-existing condition if their health plan knew that they were paying for a procedure. The Notice of Privacy Practices does not have to be distributed to all your existing residents and patients. You simply need to post that new notice in a very conspicuous location. If you have a physical facility, for those aspects of your services that are furnished in someone's home, for those of you who have home health services or other services where you're providing care to people in their independent living setting, you simply need to make it available to new patients and residents, and have it available if someone who is a current patient or resident asks for a copy. So for those folks who are doing home visits, those team members should have a copy on them that they could provide. I also recommend highly in this day and age that everyone put their notice on their website. And this is one aspect of compliance that is extremely visible, if you will. It's a public document. You have to post it publicly, and it's an easy one for OCR to establish whether or not you're in compliance. So it is something that I think is critical. You do not need to obtain a new acknowledgement for those existing patients or residents who request a copy of the new notice. All you have to do is obtain an acknowledgement one time. But obviously, for all of your new residents and patients, you would need to get that acknowledgement at least the first time they receive the notice. With that, I'm going to turn to business associates. I think that this is one of the more difficult provisions in the rule to apply. I think it's easy to kind of explain it, but in application, it is extremely difficult. And for Rob and John and I, it never fails that someone can always stump us in terms of, is it a business associate relationship or not? Because there are so many different overlapping relationships that healthcare providers have with other healthcare providers. So let's talk about first the timing of new business associate agreements, just to get that out of the way. So for those arrangements that were in place prior to January 25th, for which you had a fully compliant business associate agreement in place, you have until September of next year to get a new business associate agreement in place. For any arrangements that you entered into or amended in the last 8-9 months since January 25th, you will need to get a new business associate agreement in place as soon as possible. The deadline is September 23rd, but I will tell you, I work with all of our industry practice groups, and there are very few people who have finalized all of their business associate agreements, even for those that do need to be updated by the 23rd. So my recommendation here is that you act as quickly as you're able, but at least try to send out a letter, if not providing that new BAA, alerting folks, your vendors, to the fact that one will be coming and that you are looking to get that executed as soon as possible. So the changes, I mentioned that the definition has been expanded, that there has been clarification in terms of how the government will view liability vis-a-vis covered entities and their business associates, and also business associates and their subcontractors. And there's some new considerations I want to talk to you about related to business associate agreements. One thing that is always so hard for people to understand is a business associate is someone, or a vendor, an entity, a person who is assisting you in an administrative activity, your healthcare operations or a payment function on your behalf. And that is so important, critically important for people to understand. So the classic example that Rob and I would get is if you have an individual who is working with take, for example, the situation of hospice, where a hospice is furnishing services to a patient in a skilled nursing facility. The skilled nursing facility and the hospice obviously are required by law to have a written agreement in place. Part of that is to ensure that the payment, the pass-through payment for room and board is documented in writing. But in that situation, both the hospice and the skilled nursing facility are independently treating that patient. Neither of them is doing anything on behalf of one another. The pass-through of the payment is simply the payment mechanism. It is not unlike a situation where a person who has, say, long-term care insurance is making payments on behalf of the policyholder. You don't become a business associate of that long-term care insurer. You simply receive payments from them, and you might have a written document that lays out the terms of that payment, but that does not mean they are doing something on your behalf. In fact, they are working on behalf of the policyholder. I hope that is a helpful example. The rule does identify specifically certain types of business associates, and we here at Reinhardt are your business associate, actuarial consultants, accountants, consultants who assist with billing and other types of audits and assessments are going to be your business associates. One note for you, when you're dealing with these special categories of business associates, remember that they occupy maybe a different type of risk for you than would your claims processing or management company or someone who is doing lots of data analysis or billing for you. Those folks are going to have lots of access to PHI. Your lawyers will have intermittent and limited access to PHI, and in fact, if you're following minimum necessary, it's very unlikely that we would have a lot of PHI in our possession at any given time. So the expansion of the rule was twofold. They applied it very specifically to e-prescribing gateways, vendors of personal health records, and to the subcontractors of business associates. Previously, it was unclear whether or not the business associate rules would apply to the subcontractor of a business associate. So for example, Reinhardt often will obtain the assistance of a consultant when we are assisting our clients in dealing with a billing matter. That individual will be under contract to Reinhardt because they're assisting us in providing legal advice to our client. In that case, that subcontractor is a business associate and needs to comply with all the business associate provisions. Previously, most people had some kind of a basic confidentiality agreement in place, but now business associates are required to have a full business associate agreement in place with those subcontractors. The other important addition is the word maintain, which is underlined on this particular slide 13. And it used to be the case that record storage companies were not deemed to be business associates because typically they don't review the PHI. They simply maintain the box that has the files in it if you have old paper records, for example. The more modern example of that would be a software vendor or other service provider that may not be accessing your PHI on a routine basis, maybe only access it on a very infrequent basis. But anyone who helps maintain your PHI, whether it be the Iron Mountain Storage Company or some kind of software vendor, is going to be a business associate now. And it's critical that you make sure that you think expansively about who you might need to add to your list. Business associate, the term itself, the definition, does not include a healthcare provider who is using or disclosing PHI to treat an individual. And I gave you the hospice example. Another good example would be an attending physician. So the community physician who comes into a nursing facility to attend to their patient is not your business associate. Contrast that with your medical director who, if they are an independent contractor and not a member of your workforce, might be a business associate, and we'll talk about that in just a moment. Members of your workforce, even if they're independent contractors and not your true employees, so this would include volunteers, this would include students, other trainees who are coming into your facility. Anyone who's a member of your workforce is not going to be a business associate. That does not mean that it is not critical that you consider whether or not you want them to sign a confidentiality statement or to receive, particularly here it's important that they do receive some level of training regarding your policies and procedures and what they need to do to comply with HIPAA. And a classic example of that is your student, your nursing student, or other CNA students who are looking for experience for their clinicals. Those folks are not going to be your business associates. You're not doing anything on their behalf. You're providing a training opportunity which is consistent with your healthcare operations. However, you probably want the school to make sure that they've trained people. You might want to have an introductory orientation with them explaining the importance of following your policies and procedures. And it doesn't have to be that they attend hours and hours of training. You just need to do something to document that you've educated them. I mentioned just a moment ago that your medical director might be a business associate. I think that when you're dealing with business associates for the very reason that the stakes are much higher, you could choose to treat your medical director as a member of your workforce, but it would be critically important if you do that physician actually receive training on your policies and procedures and understands that they are operating under your rules when they're handling your PHI. It's often the case that you might have a hybrid approach where you would train your medical director what your policies and procedures are, but you might also want the protection, if they're an independent contractor, of a contract, which would give you a contractual right to seek remedies in the event that they do not follow your policies and procedures. Persons or entities that participate in an organized healthcare arrangement are not going to be your business associates. I did give the example of a hospital medical staff member, but I know that a lot of our clients really offer services among an entire continuum of care and might be working closely with other healthcare providers in town, perhaps a hospital, in engaging in various quality assurance activities, other healthcare operation related activities. And in that particular example, they would not be your business associate. A plan sponsor is also not a business associate. A word on vicarious liability. Covered entities may have vicarious liability for the noncompliance of their business associate if that business associate is deemed to be an agent under federal law, common law. Now, that is really not very helpful even for a lawyer to make a determination up front whether or not a business associate is going to be an agent, because federal common law provides that it is going to be a facts and circumstances analysis. So you will always be judged in hindsight as to whether or not a particular business associate is your agent or not. The fact that you put in your contract that you are both independent contractors and that there is no agency relationship will not be determinative. This is particularly important because under agency rules, when the business associate, or I should say under the HIPAA regulations, when an agent has notice of a breach, for example, that is deemed to be notice to the covered entity simply because of that agency relationship. So what this means is, as a practical matter, you need to be really on point with your business associates about how they're using your PHI, what they're doing with it, and assurances that they are safeguarding it in compliance with the rule, because to the extent that they are not doing what they're supposed to be doing, and you know of that, I think that's going to be fruitful grounds for a potential liability or other event. Business associates can have vicarious liability for their subcontractors who are non-compliant, so that is something to consider if, for example, you provide management services to other facilities and you hire people to help you do that. And last but not least, it's going to sound like I'm talking out of both sides of my mouth, but agreeing to be a business associate does create contractual obligations and additional risk. So I think it's important that when you're asked to be a business associate, that you're careful in determining whether or not you truly are a business associate. And again, the classic example that we see frequently in our hospice as well as our long-term care practice is the hospice nursing facility relationship. That is not a business associate relationship. Another example might be a pharmacy. Compare a pharmacy with a pharmacy benefits management company, which might offer pharmacy services as well as certain pharmacy benefit or pharmacy management services. That's going to be a business associate. There might be an aspect to the service they're providing, those pharmacy services that are not business associate services, but any of the administrative services that they're furnishing would make them a business associate. The same may be true with your medical director. They might be a business associate for purposes of the regulatory or the administrative services they're furnishing, but I know that medical directors often serve as attending physician for residents who may not have an attending physician, and in doing so they're acting as a treating provider and not a business associate. So I probably added to the confusion, but we are very happy to answer questions, obviously, when we wrap up the presentation part of our meeting today. Certain provisions that I want our clients to be thinking about in terms of their business associate agreements. The security rule is something that many people, even covered entities, are not compliant with. I would say this is an extremely high-risk area for folks who utilize an electronic health records vendor who is maintaining PHI on off-site or their server. So if someone else is hosting your server for your PHI, this security rule compliance is really, really a big issue for you because you are completely reliant, almost, not completely, but nearly reliant entirely on your business associate for your security reliance. And so it's critically important that you and your business associate have a good understanding of who is doing what to ensure that the security rule is complied with. The security rule is really a focus of enforcement right now. And I just want to put that out there. That's not the focus of our conversation today. But for those of you who have not yet implemented the security rule, I would strongly advise that you reach out to Rob or John and think about how you're going to be making sure you are compliant with that. I have here a provision on limitation on subcontractors. I like to call this, who has your PHI? Where is your PHI? And it's really important when you have business associates that you either limit their ability to share your PHI with others or require them to keep track of PHI that their subcontractors are using. And the classic example I can give you, and I can't tell you how many times this has happened, is where a consultant has a laptop stolen or loses a laptop and or a flash drive or some other portable media device. And at that point in time, they have no idea whose PHI happens to be on that laptop. It's sort of like having someone steal your wallet or your purse. You probably have a pretty good idea of what's on it, but you really don't know. So it's critically important that your business associates, if they're going to use subcontractors, keep track of whether your PHI is going to be provided to the subcontractor and what PHI will be provided to the subcontractor. I have here notice of non-permitted use or disclosure, not just breach. Since the inception of the privacy rule, a business associate has been required to promptly inform the covered entity of any use or disclosure of PHI that was not permitted either under the business associate agreement or under the rule. So it was very interesting to me when the breach notification rule came out that people were so shocked that they were going to have to advise covered entities of misuse of or wrongful disclosure of PHI because they always had that duty. What the breach notification really is about is whether or not the individual whose PHI was wrongly used or disclosed is going to know about it. That really is what that rule comes down to. It's notice to the individual. So it is not a new thing for business associates to be required to tell you about their accidents, their oopses, if you will. However, I will tell you, I don't think I've ever received a call from a client, and we work actually nationally in this area, where they have been notified of a non-permitted use or disclosure prior to the breach notification rule, and even after the breach notification rule. It is not very common for a consultant or a business associate to notify a covered entity of a breach. So hopefully that's changing, but awareness is key here. And I will tell you that most agreements I see are written so as to require notification if there is a quote-unquote breach. And what I want to stress to you is that you want to know about any use or disclosure that doesn't comply with the rule or the agreement, not just those that your business associate has determined are or are not a breach, or I should say are a breach. So you're missing out on information that could be critical to you, not clear in your agreement that you want to know everything that happens that isn't supposed to. Audit rights and records retention requirements. In the event that your business associate does have some kind of a breach, it's going to be critical that you are able to ascertain what their level of compliance was, and also you might need to see not only their policies and procedures, but you might want an ability to check their systems with your IT people to see whether or not the PHI was accessed or not. And so you have to have that audit right in your business associate agreement if you want to be able to do that, and I would highly recommend it. Indemnification is a topic for another seminar, but it is now a very common provision in business associate agreements, and it's actually a concept that is not even well understood by most attorneys. So that's something that I would strongly advise you review with your counsel to be sure that you have the protection that you need. All right. Let's talk a little bit about the new breach standard. And this is kind of a scary picture to me, the scream, but it really, truly was something to be scared of. When it came out in the new rule in January of this year, I was shocked at how broad the rule is now, and I'm going to talk to you about that. But this really is where I think the stakes have gone up considerably related to handling a PHI. So let's talk about it. The breach notification rule came out in 2009, August 24th of 2009. Many of our folks we're talking to may or may not have ever implemented a breach notification policy, which would describe how they're going to handle misuse of PHI and what their process will be for ascertaining whether or not notification is necessary. I cannot stress enough how important it is that you have a good process in place now that the standards have changed. A breach is the acquisition, access, use, or disclosure of PHI in a manner that is not permitted by HIPAA, and I think we can all get our arms around that. So you shouldn't have used it that way. You shouldn't have disclosed it to that person. You didn't have a right to access it, or someone is trying to acquire it that shouldn't. So that part's easy. Here's the tricky part. It's a non-permitted use or disclosure that compromises the privacy or security of the PHI. And this is really where all of the magic happens. So they say, under the interim final rule that was effective in August of 2009, the compromise determination was based on an individual assessment of risk of harm to the individual. So in order to find that you needed to notify your patient of a breach, you would have to determine that there was a significant risk of financial, reputational, or other harm to that person because of the non-permitted use or disclosure. So it was very often the case, with the exception of large-scale data breaches, very often we were able to conclude that there was not a quote-unquote breach that required notification because the situation did not present a significant risk of harm to the individual. OCR was very unhappy, and many privacy experts were very disappointed with that particular standard because it was so subjective, and they felt that they needed to change the standard because it was not sufficiently narrow, and there were many what they felt breaches that weren't being treated as such because of the subjective determination. So what they've flipped the rule completely, and now they have a presumption that PHI is compromised. So you are presumed to have a breach on your hands unless you can demonstrate that there's a low probability that the PHI was compromised. And compromise now is assessed based on 4 factors. These are the 4 factors. So you need to assess for every time you have a use or disclosure that may not comply with the rule, doesn't comply with the rule, you need to figure out, looking at these 4 factors, whether or not there is more than a low probability that there is a compromise to the PHI. And this is a really, I think, it's not different than the factors that were suggested that people used before, but what the really difficult thing is you have to overcome the presumption. And you have to document to prove that it's a low risk. So what are you going to do? You're going to look at the nature and the extent of the PHI involved. Was it sensitive information, mental health information, something about HIV status? Was it financial information, social security number, birth date, things that people could use to steal identity, versus a cholesterol, results from a cholesterol test. And those are sort of, the continuum that I offer to kind of assess whether or not you think that there's a risk of compromise. Obviously, the more sensitive the information, the higher burden you're going to have to overcome to say it's a low probability that there was compromised PHI. The person to who the PHI was disclosed or who used it, is that someone who was another covered entity and might have their own obligations to keep that information confidential, or was it a third party? Did you just send really sensitive confidential information out there on the internet on someone's Facebook page, or to a third party that has no obligation to follow the privacy rule? A third factor is whether the PHI was actually acquired or viewed, and the classic example of this is someone receives an envelope sealed, someone receives in the mail an envelope from a provider, and they indicate that they call up the provider and say, I got a letter today, I've never been to your facility, I don't think this was intended for me, or maybe they just write return to sender on it if you're really lucky, and you get it back and it's never been opened. Obviously that's going to help you establish that there's a low probability. It may be the case here on this factor that if a laptop is stolen, you may never know. It really depends on how that computer laptop was set up. Obviously, if there's encryption, then then you're going to have automatically you're going to be able to say it's a low risk. But again, you have to look at all these factors and weigh them. The extent to which the risks have been mitigated, and this really goes to, did you get back the PHI, or did you get some kind of a written statement from the party who got it erroneously that they've destroyed it properly, or they've given it back to you, or they're going to give it back to you. And that sometimes is easier said than done. There are 3 exceptions to the breach rule, and we could really have a whole seminar on breach, but I want to note for you that the unintentional acquisition, access, or use of PHI by a workforce member, so the nurse looks up the wrong Mary Smith's record or opens Heather's record instead of Rob's, that's not going to be a breach. Compare that with I send Mary Smith's health information to an affiliated or another provider, and they have no relationship with Mary Smith whatsoever, and that might need to be analyzed as a breach. The inadvertent disclosure of PHI from an authorized person to another. So let's say you sent your medical director records for Mary Smith, who's Mary A. Smith, and you really meant to send Mary B. Smith. That medical director was supposed to look at the records. They were authorized to look at the records. It was inadvertent. And in those cases, I think it's going to be pretty easy just to get it back, or to conclude that there really is no compromise because the person wasn't able to even retain retention. And that's our third exception. If you have a good faith belief that the unauthorized individual was not able to retain the information. And the example given in the preamble commentary to the rule is a nurse who provides discharge instructions for one patient to another patient and immediately realizes her mistake and goes back out into the waiting room and takes that piece of paper back from the patient. They offer that as an example of where you could have that good faith belief that the unauthorized individual would not be able to retain the information. Additional breach changes. It used to be that if you had a misfire of a limited data set that didn't include date of birth or zip code, it wasn't a breach. That is now presumed to be a breach. And the minimum necessary rule. Violations of the minimum necessary rule need to be analyzed as potential breaches. So I think that that's a really important change to really think about, and one that I think a lot of people don't consider, the fact that when you violate the minimum necessary rule, that could be a breach. So a good example of that is when you have a consultant that is doing some claims reviews for you. It may or may not be necessary for them to have access to the full medical record, and indeed when they prepare their report and share that with others, perhaps third parties, it's not necessary for that report to contain any identifying information. You can simply code and number the claims. Claim 1, here was the result. You don't need to say Heather Fields and my social security number and my birth date. It's unnecessary information. And for healthcare operations activities, which an audit would be, you have to comply with minimum necessary, only that PHI necessary to get the job done. High-risk activities, I mentioned this here just because these are the source of most large-scale breaches. Unsecure portable media devices, those laptops, flash drives, smartphones, iPads, anything where someone is storing PHI. We have lots of clients that are emailing PHI to one another. Email is not a secure way of transmitting PHI, particularly where people will forward work emails to their home email. That is not a secure environment. Failing to encrypt your portable media devices where PHI resides is a high-risk activity in and of itself, and one that people don't often think about, but the failure to properly destroy or remove electronic PHI prior to disposing of a device is a high-risk activity, as for those of you who may or may not have heard, there was a recent settlement in the millions with a health plan out east that returned leased copy machines without cleaning all the PHI off those copy machines. Most copy machines nowadays are actually scanners that maintain data, and so they had to send a notice to all 344,000 enrollees because they had no idea of knowing which of those enrollees had PHI on the machine. So something to think about. All right, let's talk about some other changes. We've covered the notice, we've covered business associates, and we've also talked about breach. So I wanted to cover a few other items, and this is actually probably one of the few silver linings of the changes. They expanded the information that could be shared with your development department or your fundraising folks. So now a healthcare provider can provide to their fundraising staff or their fundraising business associate demographic information, which was permitted before, but now it's broader, but also the name of the attending physician, the insurance status of the individual, and outcomes. I have talked to more than one development director who's received a very unhappy phone call from someone who wasn't so happy with the care or treatment they received, and received a fundraising notification, and they're very upset that their information would have been provided for that purpose. So this can be extremely useful. This is also useful, obviously, if you want to target your fundraising efforts to people who are receiving certain types of services from you. You do, as I mentioned, have to provide individuals an option to opt out on all of your fundraising communications. So you need to put on your communications that you send out either a phone number or an email or both, providing them an opportunity to tell you that they don't want to receive further communications. Now, it's very interesting, but the government has concluded that requiring someone to put a stamp on an envelope is an undue burden. Apparently, they get their phone service and their internet service for free, but they have concluded that the 46 cents is an undue burden, and that you may not require people to notify you in writing that they no longer want to receive fundraising communications. So that's something that we've seen a lot of notices that indicate you have to communicate in writing. And unless you want to send people a self-addressed stamped envelope with your fundraising communications, which could be quite costly, you no longer are permitted to do that. And I want to finally note, in terms of implementation, it's going to be really critical that you have some system to manage who opts out. Patients who are unhappy about being contacted are a good source of privacy complaints. So you need to make sure that if someone says, don't send it to me, that you truly have a way of tracking that. And I will tell you that some people actually offer patients and residents the phone number of their development office rather than the privacy officer, just so that to actually manage the mailing list, receive notice that a person is opting out. Completely up to you how you handle it, but just make sure you've given that some thought. A little bit on marketing. This is something that really confuses a lot of people, and the reason for it is that healthcare operations includes the ability of a provider to communicate with patients and residents the products and services that that particular provider furnishes. So if you want to make your residents or your patients aware of a new service line or a new offering that you have, that is permissible. You have to use the minimum necessary in terms of what information you would share to target them, but that's a permissible healthcare operations activity. And you'll notice in any notice you receive from a health provider and those that samples that are out there, that it says we can communicate information to you about products and services that you might be interested in. That is true, and it falls within healthcare operations only if you, the provider, are actually furnishing the product or service. If it is a third party, that is marketing. So it's only healthcare ops if it's you do it, you are providing the service. It becomes marketing if it's a third party. So if you were going to, partner with a massage therapy business in town, and they wanted to offer a free chair massage to everyone in your facility or your independent living facility, and they were willing to pay the cost of that, and they wanted your list of patients or residents, that is not permitted unless you obtain the authorization in advance of all those individuals whose names and addresses you're going to be sharing with that massage therapy company. So this is really important for you to understand. Third-party communications are not permitted, and there is an exception for this for refill reminders. And there's actually a big case out there right now where one of the companies that provides refill reminders has sued under the First Amendment to say that this marketing provision violates their First Amendment rights to communicate with people. So it'll be interesting where that goes. Sale of PHI, I don't think I've encountered any clients who ever thought that they could sell PHI, but if there was ever any misunderstanding about that, you can't sell your PHI, whether it's direct or indirect. So give us your mailing list and we'll give you money for redecorating your waiting room. That doesn't work. And I don't think anyone thought that, but this really was put in place not so much for healthcare providers that we tend to work with, but more for organizations that do a lot of research and sell databases or access to databases, and that can be a really tricky area. Let's talk a little bit about individual rights. There were some select changes. As I mentioned previously, individuals can request to restrict disclosure of their health information to a health plan, so it's a limited exception if they paid for everything in advance. This can be very difficult to manage because obviously if someone pays for one episode of care or one unique aspect of their care, it's built into their medical record. So if someone comes to audit the medical record, it would be very difficult to have to redact almost that information. But leave it to say that you have a right to ask for this restriction if you self-pay. And I wanted to spend a little bit of time because we do get a lot of calls about the rights of family members to receive the PHI of deceased individuals. So covered entities are required to protect PHI of individuals for 50 years after the date of their death. And it's very interesting because there was a huge move by a lot of academic trade organizations to push for a 2-year protection after the date of death because people want to access this PHI for research purposes. So it's very, very interesting. But the OCR said, nope, 50 years, we feel that you need to protect information for 50 years. And that means that when someone is deceased, their information gets protected just the same as someone who is alive and well, or at least alive, I should say. Now, there was a lot of concern on the part of advocates that if someone is alive, family members and friends, folks who are paying for their health care could get limited information about status and their health care because, and you'll notice in the Notice of Privacy Practices it talks about friends and family and that we might share information with friends and tell us not to. And so there was a concern that why should people who have had relatives who have died not have the same right to get some basic information about their friend or loved one. So what they did is create a very narrow exception, and it's subject to state law, and said, okay, you can disclose PHI after death to family members or other relatives or close friends who are involved in the care or care of the patient or involved in paying for the care of the patient, but only to the extent that such person was involved in the care or involved in the treatment. So the example of this is someone dies and a family member who maybe lives out of the state or who was not there calls the facility and wants to talk to the nurse or other caregiver about, someone's passing and was it peaceful or what happened or I just don't understand, just basic questions about the event itself. What this does not allow, and it's critical people understand, is for siblings who are fighting over an estate to have free reign to get a full copy of medical records from your facility because they're trying to prove that mom or dad didn't know what they were doing or wasn't fully cognizant of their decision when they signed away the farm. You may not give out copies of medical records under this very narrow exception. So that's really important to realize. In the great state of Wisconsin, you are limited to sharing information with the personal representative or the, who's usually the executor or the administrator of the state or someone who has a durable power of attorney. The healthcare power of attorney, that healthcare power of attorney expires when the person dies. So it would have to be a durable power of attorney in order for that person to have a right to get at someone's medical records because their records become part of the estate after they pass. Let's talk a little bit about review what the immediate compliance steps are, and then I think we're starting to get questions in, and so I wanted to make sure we left time for questions. You need to immediately update your Notice of Privacy Practices. It is very easy for someone to ascertain your compliance simply by looking on your website. So please make sure you get that done. We are happy to help and are able, ready, willing to help you do that. I will tell you that while the additions are fairly straightforward and simple, we've noticed in many notices that we've received language that may or may not be consistent with current interpretations of the privacy rule, and we've ended up making a number of revisions to the notice just to make sure it's consistent with current best practice. Business associate agreements, you need to update those. We are also advising clients to really give thought to who is their business associate, but also to evaluate carefully situations where they have been asked to sign a business associate agreement. Obviously, breach notification, the rule has changed so substantially that it's critical that you ensure that you are working on updating your policy and the forms that you use to process breaches. I will say that what's critical here is that your practice reflect current law. So even if your policy is still under review and updating, I think as long as you realize that come Monday, if someone has a use or disclosure, a PHI that does not comply with the rule, you need to be thinking about that and doing a full investigation and documenting your findings so that you can conclude whether or not you need to notify the individual. There will likely be other policies and procedures that need to be updated. Many people have a policy procedure regarding their notice, regarding their business associates, and those policies and procedures will need to be updated, but I think that is less critical to take care of immediately. And last but not least, providing updated training is so critical, particularly with respect to that breach notification change. It's more important than ever that folks are made aware of what they need to tell you about, and the very worst situation is where someone does not come forward even though they had an accidental, they sent information to the wrong address or they had an oops. You really want people coming forward and telling you, because that's the only way you can ensure your compliance with the rule. If your workforce member discloses PHI or uses PHI inappropriately and does not tell you about that, the clock to notify that individual runs out in 60 days from the date that they became aware of the accident, the misuse, the wrongful disclosure, regardless of whether or not they told you about it. So this is one of those things, we're working with so many people on compliance right now. This is really one of those things where you want an open environment where people can come forward. Everyone makes mistakes. You don't want to make the same mistake multiple times, but everyone makes mistakes, and you want people making sure they alert you to problems early so that you can deal with them. I think with that, we are going to conclude our formal remarks, but we have received a number of questions already, and my colleague John Richter is going to talk to us about those questions.
Just before we do that, Ms. Rodsky, I just wanted to make the point that we have seen just a variety of sample policies, procedures, business associate agreements, and whatever. And the Internet at the moment is really filled with samples and a variety of things. Some of them are relatively well done. There are many that are not, and frankly are not compliant with the new requirements. So I would just caution you to be thoughtful and careful about that. If you are working off of template kind of a sample document, you want to be certain that that document is in fact compliant with all the current requirements and does in fact represent an excellent version of whatever document you're attempting to produce. We have seen some, unfortunately, that really are if you have questions or there's concerns about that, we're happy to to take a look at the documents for you. If they are compliant, if you're good to go, we're happy to do that and off and running. If they need minor revisions, etc., to make them compliant, we're happy to do that. But if you have questions with respect to it, please feel free to contact us in the future. We're happy to talk it through with you and help you along. The other point, too, that Heather made as far as the training process, one of the things that I think a lot of clients have struggled with is how to educate their key staff involved in HIPAA-HITECH compliance. Clearly, their compliance officer, but also other key individuals, and comply with the requirements for ongoing training to the extent that you have that need and you want to educate your staff. We're certainly happy and are conducting training sessions that have been very effective in getting people up to speed and answering questions that are specific to your particular and moving forward your compliance efforts of your policies and procedures so that they're discussed earlier. John?
Well, we've received a number of really excellent questions, so I'm going to go through them starting in the order that we received them. The first question has come in and asks this. this organization is a supporting foundation that is legally distinct and separate from the healthcare providing retirement community, the CCRC, that it raises funds for. This foundation receives resident names and addresses from the CCRC and houses that information in its databases, and then in turn uses that information for fundraising purposes, like probably many of the foundations for which many of you work. So a couple questions that this individual has raised. Is the resident information that is housed in their database considered to be protected health information? That's the first question. We can kind of tick through these in order. And
yes, John, that's an excellent question. And the rule does permit the sharing of PHI with an organizationally related foundation. That is a permitted disclosure and or use depending on how you've set up your organizational structure. There can be no question that that information needs to be afforded great protection, and even having someone's name, address, birth date, that information is part of the designated record set. It is protected by HIPAA, and even though the foundation may not be a covered entity, it may be providing the service, certainly in this case is providing the fundraising on behalf of the covered entity, and in that role would either be part of an affiliated covered entity or a business associate. And I don't think that I can stress enough that even though the foundation is distinct and separate, they need to be safeguarding that information.
the follow-up question that has been asked by this individual is whether that organization, that foundation, needs to request business associate agreements for any vendors that the foundation allows to have access to this data.
I would say yes.
I think I would agree with that. I think it's just better to err on the side of caution there, given the high number of individuals there and given the potential risk. The second question that we've received, are general construction / maintenance contractors considered to be business associates?
That's a great question. I often get this question in relation to housekeeping staff as well. Clearly, construction workers do not need to utilize PHI to perform services on your behalf, and so they would fail the test right then and there. Incidental exposure, if you will, to PHI happens in healthcare all the time. If you go to a hospital, if you go to a doctor's office, anywhere, you're sitting in the waiting room, you're going to hear people's names. You might hear conversations that take place with care providers and family members or patients. So to the extent that someone is doing construction work in a facility and might overhear or have incidental exposure to PHI, that does not make them a business associate. A business associate is someone who is doing a service on your behalf and requires PHI to perform that service. And so, your housekeeping staff likely won't be business associates, but it really depends, particularly if you have facilities where you have to make the housekeeping staff aware of people who have communicable diseases, or they might have access to PHI just so that they know the proper way to handle particular illnesses, patient situations. Maybe you want to treat those people as business associates, but your office cleaning staff, for example, and your administrative offices, you shouldn't have PHI available for them to access anyway. So, I mean, that party is not going to be a business associate. I hope that's helpful, John.
I think that certainly answers the question. Regardless of the status, just a word of caution to remember minimum necessary and to kind of let that guide you in the use and disclosure of any patient information. The next question that we received is, who should an organization or an entity contact if they, say, receive an errant fax from a clinic or a hospital with information that pertains to someone who is not a resident?
That's a great question. And actually, now that the breach notification rule has changed and people are more aware of it, I get this question frequently. I think here is for me, it's the golden rule principle would apply. And if you get something that was not intended for you, I think it's polite. It's the right thing to do to call them, let them know you got it, and that you're putting it in the shredder. If they ask you to shoot them an email to let you know, to verify that was done, or if they ask you to put it in an envelope and send it back, I would do that because it's going to be you next time who needs to make that phone call, or would hope that someone would get back to you, and that's how I would handle it. Obviously, there's no legal requirement to do that, but as a healthcare provider, I wouldn't want PHI in my possession that isn't for one of my patients, so at a very minimum, you should immediately destroy that information.
And I guess just as a follow-up to that, treat that information as you would any other PHI that you would be destroying. So just leaving it in a wastebasket is not as good as shredding it.
Yeah, in fact, in Wisconsin, you are required to shred there are statutory disposal methods for health information, and short of burning it or otherwise, I don't know what else you would do to it, you need to shred it. So just a note on that.
The next question, very, very general, asking if we can recommend any sources for more information about breach notification.
Well, I guess I would say a couple things. I think that there's nothing like good old-fashioned read it yourself. OCR has posted the breach notification rule and guidance related to it on their website. And I would encourage anyone who wants more information to certainly read that. I am a founding board member of HIPAA-HITECH, and I know that they have a number of resources available, as well as very reasonably priced educational opportunities, free training that's available on their website. I think one thing I want to caution, and this is something that Rob mentioned previously, simply because you obtain a sample policy or procedure, even from a friend or a colleague, what I see happen often when I have a compliance problem and I look at people's policies and procedures, I either see a template oftentimes that's never been fully implemented, so maybe not even filled out, or I see a document that doesn't actually reflect the practices of the entity. So even if you have a document that you believe is compliant, so for example, if you were to download something from HIPAA-HITECH, which has very helpful resources available, and I encourage everyone to take advantage of whatever they can, it's critical that that document really reflect what you are doing. And the other thing I will say is that not all policies are created equal. And people often trip themselves up by having, the most beautiful policy in the world with every last detail and step. It's, the thing's 20 pages long, and it is so complicated nobody could possibly ever implement it. Simple is good, and you will trip yourself up if you don't consider whether or not you need something that complex for the size and scope of your operations. So it's really important when you're getting samples and other things to work off of that you really give consideration to what you absolutely have to have in place and what you can feasibly implement. And of course, as Rob mentioned, that it complies, but on top of that, there are other considerations.
Great, and I think we are on to our final question at this point. Unless anyone has any others, I would encourage you to send those in. But the question that I have for you now, Heather, is whether the names and addresses for individuals, not residents themselves, but people who are specified as next of kin for residents at a given facility, would that information be considered to be PHI that could be used for fundraising purposes? Would an authorization be needed to use that information?
Yes, my view would be that you would need an authorization for that unless you obtained that information through some other means. So one of the things that Rob and John and I counsel people is to really consider that admissions process really an opportunity to engage family members of the resident or patient. And if you want people to offer their name and number for future fundraising efforts and they provide it to you, that's fair game. But what you can't do is call through the record and take next of kin and utilize that information without making sure you're following the rule. Now, this presents a tricky situation because you are permitted to send fundraising contacts to the patient under HIPAA. That is completely permitted under healthcare operations, subject to the opt-out rules that I explained and the limitation on the PHI. So I have seen people take next of kin and include that because that's part of the record and part of the PHI. But if you were simply going to, depending on how you're using it, if it's pure fundraising and you're using it consistent with the rule and it's in the record, I guess I would proceed with caution, but I could see where that would be permitted. But calling through records to identify people is tricky when they're next of kin and they're not the patient. I just think people are not necessarily expecting you to be utilizing their information in that way, and you want to be careful. So I guess I gave a confusing answer. My answer, let me clarify, is that you need to carefully consider whether or not if it's within the fundraising exceptions or the permitted fundraising activity. And if you think for any reason it doesn't, you want to make sure you get an authorization. And think about whether or not you collect information from family members in a different way so that you don't have to be worried about HIPAA when using it.
Thank you, Heather. At this point, we have gone through all of the questions that have been submitted. So I can do a kind of an auctioneer style going, gone, and we can hold on a few more seconds if anybody has a last minute question they want to get in. Otherwise, all right, I think we'll cut it off there. I'd like to turn it over to Rob Heath for any closing remarks and to Heather to give her the opportunity to give any closing remarks as well. Thank you.
Rob Heath, thank you everyone for joining us today. We appreciate your attendance and we hope this information has been helpful to you. In the materials, you'll notice the names and contact information for me, Heather, and John. Feel free to call us. We're happy to talk with you, give questions, comments, and we look forward to answering those questions. We also would like to invite you to explore the opportunities that exist, training or assistance that you might need as you move forward in this process. It is a challenge. At the same time, it's our clear sense that this is an opportunity for all to do an excellent job for all those people that we serve, patients, residents, and others. Their privacy and the privacy of the records that exist, and in the process, continuing to level of quality of our healthcare operations. Heather, final remarks?
Rob, I think you covered it, but I want to ask that everyone respond. We are going to send out a survey. We really do aim to provide quality programming to our clients, and we welcome any and all feedback on how we can do better and serve your needs better. So please fill those out if you would, and also let us know what other topics you'd like to hear on. Thank you so much.